Most medical treatment will carry risk, and just because something goes wrong, it doesn't necessarily mean that there is a case for negligence. When considering whether or not there is a case for negligence, we have to satisfy 3 tests. Firstly, we have to look at whether or not the healthcare provider owed that patient a duty of care. Usually in medical negligence cases, that is almost always satisfied. Secondly, we have to look at whether or not there was a breach of that duty of care. The legal test there is whether or not the patient received reasonably competent care. So healthcare providers don't have to give Rolls-Royce care, they just have to give minimally competent care. Thirdly, if we're able to prove that breach of duty, we also have to show that that breach of duty caused the outcome and the injury of which that patient is complaining. To be able to assess those tests, we work with a team of specialist medico-legal experts who are able to advise us and you on whether or not the care that you received was substandard, and if so, whether with competent care the outcome would have been different. The other thing that is important to bear in mind is that there are strict time limits. Usually in medical negligence cases, a case must be brought within 3 years of the event or of the time that you first knew that that injury was due to negligence. There are, however, exceptions to this rule, so it's really important you give us a call and we can advise you based on your own individual circumstances.